Hi, I'm Nancy Gusman. I'm the owner of Brick House Title, and tonight's topic for Wind Down Wednesdays for our investors was how to comply with Maryland's Protection of Homeowners and Foreclosure Act, or PIFA, you may have heard. Please bear with us. Tonight's presentation we were only able to record in audio, but I'm hoping that you'll get a lot out of the content on this recording. Thank you.
This law was initially enacted in 2005, had major revisions in 2008, and there have been some minor revisions since. So what I did today is I pulled down the statute, and I am more than happy to provide anybody with an actual copy of the statute, but this is how fat it is. Okay. And I went through it, and I created this thing. I just went section by section, trying to explain to you exactly what it says. Okay, so I'm going to start with, and I'm leaving out all the stuff that is related to loss mitigation. I'm just addressing the stuff that relates to investors approaching homeowners off market. So the first thing is a foreclosure consultant is somebody who negotiates with a homeowner in default to assist them in some sort of activity that will avoid a foreclosure. Okay? That's the simple explanation. Okay, and I gave you some definitions that they have in here. Okay. Well, before I say that, let me move on. Foreclosure consulting services includes arranging or facilitating the sale of the property to another party, and or arranging or facilitating for that homeowner to remain in the home after the property is sold. Think about what I just said in terms of wholesaling. Do you think that maybe that wholesaler is now a foreclosure consultant? Okay,
just action.
yes, the activity right there. Okay, so who is covered? Who as a homeowner is covered under this act? That's further down, but it's anybody. It's an owner-occupied property, 1 to 4 units. That's 60 days or more behind in the mortgage. Not very much. You get 2 months behind, and now you fall into this law. Okay? So all of this off-market solicitation, okay? If you're gonna, so we're gonna start with, you're an investor and off-market, you're going to approach a homeowner who's in default 60 days or more. Okay, so if you're gonna wholesale it, you're now a foreclosure consultant. I'm gonna get to if you're not wholesaling it later. Okay? So, if you are a real estate licensee, okay, as a few of you in here are, then you're exempt from this law if and only if you are actually acting as that homeowner's real estate agent. Okay, so they carved out an exception saying if you're the listing agent and your job is to help this person sell this property in the normal course of what listing agents do,
Then you should have a listening agreement.
then you're exempt from this law. Well, you will have a listing agreement, but then you're exempt from this law. But if you're operating as a licensee, if you're operating in any other capacity, you are not exempt. Okay? They talk about foreclosure rescue transactions. A foreclosure rescue transaction is where the homeowner conveys some interest in the property. It's either partial or all, okay? And still retains an interest. So that could be, I sell you the property and then you lease it back to me. Sometimes. Okay, because sometimes that is legal, sometimes it's not. Okay? Or it could be that, because I see this a lot, I'm in default, so I'm just going to add Ricardo onto title. And Ricardo is going to do this, that, and the next thing in order to bring the loan current and rehab the property, and we're going to do all this stuff, and then we're going to resell the property at market value. And Ricardo's going to get part of the proceeds of that sale, and I'm going to get part of the proceeds of that sale. Okay, that's foreclosure rescue.
Wait, I have a question. So why would, if you can do that, or I guess you would include him because he has the money to get the rest of that done.
People do this all the time. I will bail you out and I'll bring you current on your mortgage. They don't pay off the mortgage. They bring it current. They pay the arrearage.
Right.
I'll pay your arrearage. You just add me onto title, and then we'll work on selling the house
Split the profit.
and split the profits on it
Okay.
in some manner or another. And sometimes it's not even 50-50. The whole concept of this is that investors are preying on the ignorance of these people who are in default. These people they're ignorant, they're desperate, okay? They may not be ignorant if they weren't desperate, but because they're desperate, they are ignorant.
Right.
Does that make sense?
Right.
So you're preying on somebody's vulnerability.
They might even just sign the deed over to them and not realize that they did that.
Exactly. Exactly.
That,
Okay? So, and the whole point, the whole thing is, I'm going to rescue you from foreclosure.
Right.
I'm going to save you. Okay?
Right.
Now, if you've got somebody who owns a property free and clear, okay? I'm just using that extreme as an example. And you want to go into this thing in order to fix the property up and resell it. Okay? You don't want to buy it outright from them and then go sell it. You want to just, so you're not giving them any money up front. Okay? You're just going on title with them. And then you're putting all the money in to rehab the property. And then you're going to sell the property together. That doesn't violate this law because they're not in default on a mortgage.
Right. But just by them being in default on is what most of it illegal.
Right, because it makes it a distressed situation where they can't think clearly.
So is that only mortgage? What if it was taxes? What if they were behind
This
taxes?
is mortgage.
Only mortgage.
Yes.
And even if even if they came to an agreement and contracted, or a contractual agreement between the two parties, that would
Basically,
still
what this law is saying is that somebody who is 60 days or more in default is in such distress that they're not capable of thinking clearly. It's a legal presumption that this person is not capable of thinking clearly. This law was originated in a time period where people were in default and they had equity in their houses. And these investors would come in and strip their equity. So if you are a foreclosure consultant, okay, so this isn't the purchaser at this point, this is the foreclosure consultant, which we agreed a wholesaler probably is, okay, then you have to have a specific contract with that homeowner for the services that you're providing to sell their property. Okay? And that contract has legal requirements to it. It requires, it tells you what size font you have to use. It has statutory language in it. Okay?
If you use the wrong size font, it's not.
It's illegal. It tells you, there are certain provisions that have to be in 12 point, there are certain provisions that have to be in 14 point, and there are certain provisions that have to be in 15 point. Okay? The idea is that they want to make it obvious to this homeowner. They shouldn't have to go like this and read the fine print.
No fine print.
Okay? So a foreclosure consultant is prohibited from receiving any compensation that has not been fully disclosed to the homeowner in writing. Okay? They're prohibited from receiving any monies to be held in escrow or on a contingent basis on behalf of the homeowner. They're prohibited from acquiring any interest in the residence. So the consultant is prohibited from actually being the buyer. Okay? And you cannot have the homeowner sign a power of attorney over to you. Okay? Because that is obviously a conflict of interest. Alright? A foreclosure consultant must also be a licensed real estate agent or broker. You must carry a real estate license if you want to be a foreclosure consultant. Okay?
That wasn't
So that
always
just
the
exempt-
case, was it?
Yeah, it was.
Was it?
Now, again,
So,
there's differences between foreclosure consultants who are doing what we're talking about today and foreclosure consultants who are dealing with loss mitigation services. Okay? So you have to, and I will admit that the statute is fuzzy on that. Okay, but there is a difference between those two sets of services in the statute. Okay?
Nancy,
The foreclosure consultant owes the same fiduciary duty to that homeowner as would that homeowner's listing agent if they had one. Okay? That's a good gotcha, isn't it?
Yep.
So the homeowner has a right to rescind the contract it says within 5 days of execution. They consider execution of the deed at closing part of executing the contract. So what happens is, I'm going to write a contract to buy the property from Katie. And poor Katie's in default, okay? And I write a contract and I'm gonna buy the property from Katie, and 20 days later, 30 days later, we go to closing and I purchase the property at that settlement, and she signs all the closing documents, including the deed. She still has 5 days after settlement to rescind. So therefore, we can't disperse, we cannot record. That purchaser cannot turn around and flip the property out to somebody else in that 5-day period. Okay? Let me tell you, from a title standpoint, it's a bitch.
It's kind of hard.
Okay? If you guys are going to the MRIS, whether directly or through an agent, if you're going to the MRS and you're finding a property, you're not going to run up against PIFA, because this person hired a real estate agent to get them the highest market value for the property, and that real estate agent is protecting their interest. Okay? PIFA is where somebody comes along and says, I'm going to save you, and you don't have to pay a 6% commission to anybody. Okay? I'm going to rescue you, and I'm going to get you out from under this whole mess. Okay? In some capacity or another. Okay? And we're moving right now, I'm still in, there's a foreclosure consultant in there, but I'm moving towards directly to the purchaser. So just bear with me, guys. Okay? And I'm actually taking the statute in the order that it's written. Excuse me.
Pleasure.
Thank you. If the person rescinds in that 5-day period, then within 10 days, the buyer is obligated to get that executed deed back to that seller. Okay? Now, the reason for this is that sometimes people have tried to do this without an actual formal closing. They show up at somebody's house and they give them a check and they have them sign a deed. Okay? I know that sounds interesting, but believe me, they learned it at the Holiday Inn at some point in time or another. Okay? It is not legal for a homeowner to waive their rights under this provision. They can't waive their right to rescind. Okay? That rescission period is set in stone, just like the rescission period on a refinance and other stuff. Okay? Now I'm down to, in your outline, 7-311. The foreclosure consultant arranges for the sale of the property. They must provide a notice, and again, it's statutory language in the notice that states the total sales price of the property, an explanation of the distribution of the proceeds of that sale. It's got to be in 12-point type, and it has to be in the same language that that person speaks. I think that's interesting because I want to see somebody write a contract in Swahili or some obscure language, you know? But, okay. It has to be signed, dated, and notarized. Okay? It has to describe in detail, and I see I typed very well in number 4. It has to be described in detail the terms of the transaction, including name and contract information for the buyer, the total consideration to be given or received, okay, by both the purchaser and the foreclosure consultant, the proposed date for the consummation of the transaction, any financial or legal obligations that the homeowner is still going to have after closing, okay? So let me think, maybe we have a short sale and that homeowner might be responsible for a deficiency. Or even if they're not responsible for a deficiency, there might be a tax consequence. That needs to be disclosed as per number 6. Okay? And a notice explaining to the homeowner that they have a right to rescind the contract. Okay.
So, what kind of, what kind of obligations, legal obligations would they retain after getting rid of the property?
Well, like I just said, let's say it's a short sale, and they might be responsible for a deficiency, or they're going to have a tax consequence on that deficiency. There are financial consequences to a short sale. Obligations of the buyer. You guys ready? It doesn't matter whether you're a foreclosure consultant. You're buying the property. It doesn't matter whether a foreclosure consultant brokered the deal. Okay? What matters is that you're buying the property from somebody who is 60 days or more in default on their mortgage. Okay? You are required. Okay. Let's say, number 1, you may not represent in any way, shape, or form that you are acting on behalf of that homeowner, that you possess a license that you don't actually possess. In other words, I'm a licensed realtor, but you're not really. Okay? You cannot represent that you're assisting them in saving their house or anything along those lines.
You see so many bandits.
Or that you're assisting them in preventing a foreclosure. Okay? That's illegal. Number 2, you cannot make any statements or representations whatsoever that are deceptive or misleading, or that are likely to cause confusion or misunderstanding. And this includes statements, and I'm taking this language straight out of the statute, okay? Includes statements regarding the value of the property, the amount of proceeds the homeowner may or may not receive at closing, any term of the contract, or the homeowner's rights and obligations after closing. Okay? I'm going to expound on that in a minute. You are also prohibited until the rescission period expires. You may not record any document, and you may not transfer any interest in the property to a third party. I already addressed that part. Okay? 313. If you plan, now originally they had said it was totally prohibited to rent the property back to somebody. Okay? Now they've adjusted it a little bit. You can rent the property back to the person to keep them in there, but you cannot rent it back with a right to repurchase. Okay?
Can you rent it with a non,
You could just put them under a lease and let them rent the property.
okay, but can you rent it to somebody else other than the previous owner?
Okay. So, let's say I'm the person in default, and you buy the property from me. Okay, what this is addressing is you letting me stay in the property.
Right.
Okay? So, you can rent the property back to me, but you can't rent the property back to me with a promise of repurchase. Well, what this is saying, I mean, this isn't really prohibiting. So let's say that you buy the house and you let me stay there and I rent the property from you. 5 years down the road, potentially, I could buy the property back from you. Okay, what this is saying is that you can't rent it back to me with a promise that I can repurchase it.
So you can sell it back, you just can't promise them at that time.
Right, it's gotta be something that's negotiated later on, okay, with no guarantees. Okay, because we had all these people who thought that they were gonna be able to buy the properties back, and the investors really screwed these people over. Okay?
All right,
So number one, if you're doing a short sale, the lender requires that seller to move out of the house. If you're doing a short sale, that person cannot stay there. Okay? That has nothing to do with this law. That has to do with short sales. Okay? The lender will not permit that seller to stay in the house after they've short sold the property. Period. Okay? I can count the number of exceptions to that rule on less than one hand. Okay? Not that there aren't exceptions, because there's always exceptions. Okay? Number two, per the statute, if you do rent the property back to the people, then the contract for the sale of the property must include a description of the terms of that potential lease. Okay? And they also have to have a separate piece of paper that, I missed some, I skipped something somewhere.
You don't have that lease.
I don't know. I did, I left something out, but I'll come back to it, okay? I was working too fast this afternoon, I apologize. So, on a separate piece of paper, in 15-point type, there's a statutory language for a statement about tenancy, which explains to the person what it means to be a tenant in this property. Okay? And what their obligations as a tenant are going to be. Before I hit the last paragraph, let me go back to section 7-311 because I left something very, very important out. Okay? The seller of the property, the homeowner, when you're negotiating this transaction, that homeowner must be provided with documentation regarding the value of the property. Okay? You can't just say to the person, well, your property's only worth $60,000. You've got to show them exactly how you came up with that. You've got to show them the comps in the neighborhood. You've got to show them why, even though the house next door will sell for $135,000, your house needs a renovated bathroom, a renovated kitchen, mold remediation, and a new roof, and therefore your property's only worth $60,000.
You give them the as-is condition.
Okay? And you need to document for them how you came up with your acquisition price.
And that's the 60,000.
Okay? So it does, whatever. Okay? The bottom line is that you have to document for this person so that so here's what happens. Okay? And some of the people in this room have heard me say this before, and some of the people in this room have never heard me say this. Okay? When you're in distress, it doesn't matter what kind of distress you're in. When you're in distress, you don't think clearly, logically, reasonably. You are panicked. And somebody could tell you that you can buy oceanfront property in Arizona and you'll believe them because you're in distress. Okay? You have to think about the emotions that these people are going through. This is not a business transaction for that seller. It's a business transaction for you, and the Holiday Inn is going to teach you all day long. It's just a business transaction. If they agree to sell the property to you for $60,000, then you had a contract, and what's the big deal? It was a business transaction. No court is going to back that up. Okay? And, as I've explained in some of my other presentations, if you offer $60,000 and they accept $60,000, but you're not operating on the same set of facts, then you don't have a contract. Okay? So what this is basically saying is, when it's saying that you have to give them the documentation for how you came up with that acquisition price, basically what they're saying is you need to make sure that when they're accepting your offer, they're operating on the same set of facts that you're operating on. When it's saying that if you're going to transfer your rights to a third party for a fee, and you need to disclose it, they are operating on the same set of facts that you're operating on when they accept your offer. Okay? So basically, they've written a statute that says that you have to follow contract law. Oh my God, that is just
God forbid.
it's such a novel concept. If the homeowner sues you and they win, they get treble damages plus attorney's fees. Treble damages means that whatever it is that their damages are, they get 3 times that. Plus they get their attorney's fees. Okay? So if their damages are $100,000, they get $300,000 plus their attorney fees.
So it's like
Okay.
punitive damages, they punish you.
They do punish you. And there's criminal penalties. If you get charged with a crime on this thing, because the AG can come after you, then you're looking at up to 3 years in prison and a $10,000 fine.
On each violation.
On each violation. To me, that doesn't seem so hard. Why can't you sit down with somebody and show them the comps and say, okay, so here's how I arrived at my acquisition price. Okay, so I know that the house next door sold for $135,000. But in order for me to make this house a $135,000 house, it's going to cost me $60,000 in acquisition and rehab costs. And in the end, I need to make something. So I take that $135,000 and I subtract out 80, and that's what this property is worth to me. You can show them the math. The same math that you used to come up with what you're going to offer, why can't you show them that math? What's the harm in that?